The moment I opened my front door and saw Sharon Martinez standing on my porch with her tablet and that pursed lip expression, I knew my Thursday morning was about to go sideways. She was the president of the Ridgemont Heights Homeowners Association in Boulder, Colorado, and she had that particular look she always got when she was about to make someone's life miserable over something completely ridiculous. "Zachary Quinn," she said, tapping her tablet screen with a manicured fingernail. "We need to discuss the violation on your property." I was still holding my coffee mug, steam curling up into the crisp February air. "Good morning to you too, Sharon. What violation are you talking about?" She turned slightly and gestured toward the side of my house where I kept my winter gardening containers. "That unsightly mess. It's been reported by multiple neighbors, and frankly, it's bringing down property values." I followed her gaze to what I personally considered one of my better creative moments. Over the past few months, I had been arranging my winter garden containers, old pots, weathered wooden crates, and various planters into an increasingly complex formation. What started as simple storage had evolved into something more interesting. I had stacked them at different heights, creating levels and depth. Some containers still held the frozen remnants of winter kale and ornamental cabbage. Others were empty but positioned to catch snow in interesting ways. I had even incorporated some driftwood I found on a trip to Cape Cod last summer, along with some copper pipes that created interesting shadows. "That's not a mess," I said. "That's my winter container garden display." Sharon's nostrils flared slightly. "Mr. Quinn, the HOA covenant clearly states that all outdoor storage must be screened from view and that yards must be maintained in a neat and orderly fashion. This is neither neat nor orderly. You have until March 1st to remove it, or you'll be fined $500. March 1st. That's 2 weeks away. Then I suggest you get started." She tapped her tablet a few more times. "You'll be receiving the official notice via email within the hour. Have a nice day." She walked back down my front path, her sensible heels clicking against the flagstone. I stood there, coffee going cold in my hand, staring at my containers. Messy. It had taken me weeks to get the arrangement just right. The way the tall terracotta pots anchored the corners, the cascading effect of the smaller containers, the interplay of textures and the geometric patterns created by the wooden crates. It was intentional. It was art. But apparently, according to Sharon Martinez and the Ridgemont Heights HOA, it was just junk. I went back inside and called my friend Derek, who had been dealing with HOA nonsense for years in his own neighborhood. "They're going after your pots," he said, laughing. "Man, these people have nothing better to do." "I'm serious. $500 if I don't dismantle it, so take it apart. It's just containers, right?" I looked out my kitchen window at the display. The morning sun was hitting it perfectly, creating long shadows that emphasized the geometric arrangement. "It's more than that now. I don't know how to explain it, but it's become something. Dude, it's your yard. If you want to fight it, fight it. But is it worth the hassle?" That was the question. Was it worth fighting the HOA over some garden containers? A year ago, I would have said no. I would have just moved everything to the backyard and avoided the conflict. But something about Sharon's dismissive attitude, the way she called it an unsightly mess, without even trying to understand what she was looking at, it got under my skin. I spent the next few hours researching HOA regulations and looking for loopholes. The covenant did mention neat and orderly, but those terms were subjective. What looked orderly to me might look messy to Sharon, and vice versa. There was also a section about artistic displays and yard decorations. Technically, holiday decorations were allowed for 30 days after the holiday. Artistic displays required approval but weren't explicitly forbidden. That's when an idea started forming. If this was art, if I could legitimately call it an artistic installation, then maybe I had a case. I grabbed my camera and spent the next hour photographing the container display from every angle. I took close-ups of the textures, the way the ice had formed in some of the empty pots, the patterns created by the stacked crates. I even took some photos at dusk when the shadows got really interesting. The next morning, I printed out the best photos and drove to the monthly HOA board meeting. These meetings were open to all residents, though usually only a handful of people showed up, mostly to complain about parking or tree trimming. Sharon looked less than thrilled to see me walk in with my folder of photos. She was sitting at the head table with 4 other board members: Patricia Hendricks, the treasurer, Bob Yamamoto, the secretary, Linda Sorensen, a member-at-large, and Kevin Blackwell, the vice president. "Mr. Quinn," Sharon said flatly, "how can we help you?" I set my folder on the table. "I'm here to contest the violation notice I received yesterday. I believe you've mischaracterized my winter garden display. There's nothing to contest. The covenant is clear. Actually, it's not." I opened the folder and spread out the photographs. What you're calling clutter is actually a deliberately arranged artistic installation. I'd like to submit these photos as evidence and request that my display be reclassified as yard art, which is permitted under Section 7 of the Covenant. Bob Yamamoto leaned forward to look at the photos. He was a retired architect and had always struck me as more reasonable than Sharon. "These are quite good," he said. "I drove past your house the other day and actually noticed the arrangement. It's got a very modern sculptural quality." "It's containers stacked in a pile," Sharon said. "It's more than that," I argued. "Every element is deliberately placed. The heights create rhythm, the materials create contrast. It's no different than a sculpture or a decorative fountain." Patricia Hendricks picked up one of the photos, squinting at it. "I don't know. It does look kind of cluttered in person." "A lot of modern art looks cluttered to people who don't understand the context," I said. "That doesn't make it any less valid as art." Sharon was shaking her head before I even finished speaking. "Mr. Quinn, I appreciate your creativity, but the HOA covenant isn't open to interpretation based on personal artistic opinions. The board has determined this is a violation, and you have until March 1st to comply. If you'd like to install approved yard art, you're welcome to submit designs for our review." "I'm not submitting designs for something that's already in place. I'm asking you to recognize what's already there." Request denied. Kevin Blackwell, who had been silent up to this point, cleared his throat. "Could we at least put it to a vote? That seems fair." Sharon shot him a look that could have frozen water. "Fine. All in favor of granting Mr. Quinn's request to reclassify his container pile as approved yard art." Bob Yamamoto raised his hand. No one else did. "Motion denied," Sharon said. "Next item on the agenda." I gathered my photos, my face burning. I had expected them to say no, but the casual dismissiveness still stung. As I walked out of the community center, Bob caught up with me in the parking lot. "Hey, Zachary," he said. "For what it's worth, I think you're right. It is art. Sharon just has it out for anything that doesn't fit her vision of suburban perfection." "So what am I supposed to do? Pay the fine?" "You could take it to arbitration or small claims court if you want to go that route. The HOA has been getting more aggressive lately. Someone should probably push back." I drove home thinking about what Bob had said. Small claims court felt like overkill for a dispute about garden containers. But $500 was a lot of money, and more than that, it was the principle. I had done nothing wrong. I had created something I found beautiful on my own property. Over the next week, I did nothing to the containers. The March 1st deadline was approaching, and I knew Sharon would be watching. Sure enough, on March 2nd, I received another email. The fine had been issued, $500, payable within 30 days or subject to additional penalties. I called a lawyer. Her name was Victoria Thompson, and she specialized in HOA disputes. Her office was in downtown Boulder, a small practice above a coffee shop. "Container gardens," she said, looking over the photos I had brought. "That's a new one. Usually I'm dealing with paint colors or fence heights." "Can they really fine me for this?" "They can fine you for anything that violates the covenant. The question is whether this actually violates it. You said they mentioned the neat and orderly clause." "Right. But that's subjective." "It is, which works in your favor. Courts generally don't like HOA rules that are too vague or that give the board unlimited discretionary power. The fact that you can make a legitimate argument that this is intentional yard art creates ambiguity." "So what do I do?" Victoria leaned back in her chair. "You have a few options. Pay the fine and move on. Request arbitration through the HOA's dispute process, which is usually biased in their favor but worth trying. Or we file in small claims court and argue that the fine is invalid because you're not in violation." "How much would small claims cost?" "Filing fee is about $200. My fee for something like this would be around $1,000, maybe less if it settles quickly. So you'd be in for more than the fine itself. But if you win, the HOA might have to reimburse your legal fees." I thought about it for a moment. "Let's do it." "File in small claims." Victoria smiled. "Good. I like cases like this. Keeps the HOAs honest." We spent the next hour going over the details. Victoria asked me to write up a detailed explanation of my artistic intent, describing why I arranged the containers the way I did and what I was trying to achieve aesthetically. She also wanted more photos, especially ones that showed the display in different weather conditions and lighting. "The key is to establish that this isn't random clutter," she explained. "We need to show deliberate artistic choice. Every element should have a reason for being where it is." I went home and spent the evening writing. It felt weird at first, trying to articulate something I had mostly done intuitively. But as I wrote, I realized I did have reasons for everything. The tall pots in the back created a sense of depth. The wooden crates added warmth and organic texture against the cold ceramic and terracotta. The copper pipes introduced an industrial element that contrasted with the natural materials. The whole arrangement was meant to evoke a sense of winter resilience, of beauty persisting through the harsh season. When I finished, I had 3 pages of single-spaced text explaining my winter container installation. It sounded pretentious when I read it back, but it was honest. This was what I had been trying to create. 2 weeks later, we got our court date. Small Claims Court in Boulder County met twice a month, and we were scheduled for a Thursday afternoon in early April. Victoria filed all the necessary paperwork, including my artistic statement, the photographs, and a legal brief arguing that the HOA's fine was invalid. The HOA's response came a few days before the hearing. They filed their own brief, arguing that I was in clear violation of the covenant and that calling clutter art didn't exempt anyone from the rules. They included their own photos of my display, taken from unflattering angles that emphasized the more chaotic aspects. They also included photos of other yards in the neighborhood, showing neat, traditional landscaping as examples of what was expected. "They're not taking this seriously," Victoria said when she called to discuss their response. "That's good for us. They think the judge will just side with them automatically." "Will he or she?" It's Judge Patricia Reeves. I've been before her a few times. She's fair, doesn't automatically defer to HOAs. She'll actually look at the merits. The night before the hearing, I barely slept. I kept going over what I would say, how I would explain myself. This had started as a simple dispute about garden containers, but it had become something more. It was about whether homeowners had the right to express themselves creatively, even if that expression didn't conform to their neighbors' expectations. The Boulder County Justice Center was a modern building near the county offices. I met Victoria in the lobby, and we went through security together. The courtroom was smaller than I expected, more like a large conference room with a judge's bench at one end. Sharon Martinez was already there with the HOA's lawyer, a man in an expensive suit named Gregory Walsh. He looked like he handled corporate litigation and was slumming it in small claims court. Sharon was wearing a navy blazer and had her tablet, as always. Judge Reeves came in right at 2 o'clock. She was a woman in her 50s with short gray hair and reading glasses hanging from a chain around her neck. "Good afternoon," she said, settling into her chair. "We're here for Quinn versus Ridgemont Heights Homeowners Association. Mr. Quinn is contesting a $500 fine for an alleged covenant violation. Is everyone ready to proceed?" Both lawyers confirmed they were. "All right. Miss Thompson, your client is the plaintiff. Please present your case." Victoria stood up. "Thank you, Your Honor. This case concerns whether my client's winter garden display constitutes a violation of the HOA covenant. We argue that it does not, for several reasons. First, the covenant's language about neat and orderly is subjective and overly vague. Second, Mr. Quinn's display is not random clutter, but a deliberately arranged artistic installation. Third, the covenant explicitly allows yard art, and the HOA board failed to properly consider whether Mr. Quinn's display qualified as such before issuing the fine. She walked through each point methodically, showing the photos, reading excerpts from my artistic statement, and citing several Colorado cases where courts had ruled against HOAs for using vague or subjectively enforced rules. When it was Walsh's turn, he stood and buttoned his jacket. "Your Honor, this is quite simple. The plaintiff has accumulated various containers and objects on the side of his house in a manner that violates the community's standards for appearance. Calling something art doesn't make it immune from reasonable regulations. If we accepted that argument, any homeowner could pile up junk and claim artistic intent." "That's a slippery slope argument," Judge Reeves said. "Does the covenant define what constitutes approved yard art? It requires prior approval from the board for any decorative installations." "Did Mr. Quinn request approval?" "No, Your Honor." "Did the board inform him that he could request approval, or did they simply issue a fine?" Walsh hesitated. "The violation notice informed him of the complaint and the deadline to remedy it." Judge Reeves looked at Sharon. "Miss Martinez, you're the board president." Sharon stood up. "Yes, Your Honor." "When you spoke with Mr. Quinn, did you discuss the possibility of seeking board approval for his display?" "I told him it was a violation. There was nothing to discuss." "But you didn't mention the approval process." "It wouldn't have mattered. The board would never approve something like that." Judge Reeves raised her eyebrows. "So even if Mr. Quinn had formally requested approval, you would have denied it?" "Absolutely. It's not appropriate for the neighborhood." "Based on what criteria?" Sharon seemed flustered. "It's common sense. It looks messy." "But art is subjective, isn't it? What looks messy to you might look intentional to someone else." "Your Honor," Walsh interjected, "the board has the right to establish aesthetic standards for the community." "Within reason," Judge Reeves said. "And those standards need to be clearly articulated and fairly applied. Miss Thompson, Does your client have any other evidence to present? Victoria glanced at me. We had discussed whether I should testify. Mr. Quinn would like to speak if that's all right. Go ahead. I stood up, my heart pounding. Your Honor, I'm not an artist by profession. I'm a software developer, but I've always been interested in design and aesthetics. Last fall, I started thinking about what my garden looks like in winter. Everything dies back and it gets kind of bleak. So I started arranging my containers in a way that would create visual interest even when nothing was growing. It evolved over a couple of months. I'd move things around, try different configurations. I was trying to create something that celebrated winter instead of just waiting for spring. And did you consider it art? Judge Reeves asked. Not at first. But yeah, eventually I realized that's what it was. I was making aesthetic choices, thinking about composition and balance. That's what art is, right? That's one definition. Mr. Walsh, does the HOA covenant specifically prohibit the type of display Mr. Quinn created? It prohibits anything that's not neat and orderly. And who determines what's neat and orderly? The board. With no guidelines or standards, Walsh was silent for a moment. The board uses its reasonable judgment. Reasonable to whom? Judge Reeves flipped through the papers in front of her. I'm looking at the photographs submitted by both parties. I can see that Mr. Quinn's display is unconventional, but I can also see that it's structured. There's clear intentionality in the arrangement. The containers aren't just scattered randomly. They're stacked, grouped, and positioned in ways that create patterns. She looked at Sharon. Miss Martinez, have you ever been to a modern art museum? Sharon looked confused. I don't see what that has to do with this. Humor me, have you? Yes, a few times. Did you find all the art there beautiful? Not particularly. But you recognized it as art, I suppose. Why? Sharon struggled for an answer. Because it was in a museum. So context matters. If Mr. Quinn's containers were in a gallery, you'd call them art. But in his yard, they're clutter. A yard isn't a gallery, Your Honor. No, but it's private property. And homeowners have rights to use their property in lawful ways, even in HOA communities. Those rights can be limited by covenants, but those limitations must be reasonable and clearly defined. Judge Reeves took off her glasses and cleaned them with a cloth. Here's my concern with this case. The HOA covenant gives the board broad discretionary power to determine what's neat and orderly, but there are no clear standards. Miss Martinez admitted that even if Mr. Quinn had sought approval, she would have denied it. That suggests the board isn't applying a consistent standard, but rather making decisions based on personal preference. That's not how HOA governance is supposed to work. Walsh tried to respond, but Judge Reeves held up her hand. I'm not finished. Additionally, the covenant allows yard art but requires board approval. The HOA should have informed Mr. Quinn of this process instead of immediately issuing a fine. Mr. Quinn's display may be unconventional, but the evidence shows it's intentional and aesthetic in nature. Whether you personally find it attractive is irrelevant. The question is whether it violates a clearly articulated standard, and I don't believe the HOA has met that burden. My heart was racing. Was she about to rule in my favor? However, Judge Reeves continued, I'm also mindful that HOAs exist to maintain community standards, and some regulation of property appearance is legitimate. So here's my ruling. The $500 fine is invalidated. The HOA failed to provide Mr. Quinn with adequate notice of the approval process and failed to apply clearly defined standards. The fine was arbitrary and capricious. Victoria touched my arm, smiling. Furthermore, Judge Reeves said, I'm ruling that Mr. Quinn's winter container display constitutes yard art and is therefore a protected installation under the covenant. The HOA may not require its removal without a legitimate, articulable reason beyond aesthetic preference. If the board believes it violates a specific, clearly defined standard, they may bring another action, but they must cite that specific standard. Do both parties understand this ruling? Yes, Your Honor, Victoria said. Walsh looked at Sharon, who was sitting rigid in her chair, her face red. We understand, Your Honor, he said tightly. Good. The HOA will reimburse Mr. Quinn for his filing fees and reasonable attorney's fees. Miss Thompson, please submit a fee statement within 10 days. This case is dismissed. The gavel came down, and I let out a breath I didn't know I'd been holding. We had won. Not only that, but my container display was now legally recognized as art and protected from future HOA complaints. Outside the courtroom, Victoria was grinning. That was better than I expected. Judge Reeves really nailed them on the arbitrary enforcement issue. So they can't make me take it down. Not without a very specific reason that doesn't boil down to we don't like how it looks. You should probably formalize it a bit, though. Make it clear it's intentional. Maybe add a small plaque or something that identifies it as an installation. Sharon and Walsh walked past us without making eye contact. I could hear Sharon muttering something about ridiculous and precedent. The story could have ended there, and I would have been happy. I had my containers, the fine was gone, and I had legal protection from future harassment. But things got weird fast. The local newspaper, the Boulder Daily Camera, somehow got wind of the case. A reporter named Jennifer Kozlov called me 2 days after the hearing. Mr. Quinn, I'm doing a story about your case against the HOA. Do you have time to talk? How did you hear about it? Court filings are public record. And honestly, it's a great human interest story. Local artist defeats HOA, judge declares container garden to be art. Our readers love this stuff. I wouldn't have called myself an artist, but I agreed to an interview. Jennifer came to my house that afternoon with a photographer. They took pictures of the container display from every angle and asked me questions about my artistic process, my dispute with the HOA, and what it felt like to win in court. The article ran on Sunday, front page of the local section. The headline read, Boulder Man's Garden Containers Declared Art in HOA Dispute. They had used one of the better photos, showing the display in afternoon light with the mountains in the background. It actually did look impressive. My phone started ringing almost immediately. Friends, former co-workers, even some distant relatives calling to congratulate me. A few local artists reached out, saying they appreciated someone standing up for creative expression. One guy invited me to join a neighborhood art collective. Then things got really strange. A gallery owner from Denver called and asked if I'd be interested in creating a similar installation for a group show about suburban art. I politely declined. A garden design company wanted to feature my containers in their spring catalog. Also declined. The attention was flattering but overwhelming. I hadn't set out to make a statement about art or HOAs. I just wanted to keep my containers arranged the way I liked them. But Sharon Martinez wasn't done with me. A week after the article ran, I got a call from Victoria. The HOA is appealing the decision, she said. They can do that. It was small claims court. They can appeal to the district court, argue that Judge Reeves made an error in her ruling. It's unusual for small claims cases, but they can try. Why would they waste the money? Pride, mostly. Sharon probably got blowback from other board members for losing, and they might be worried about the precedent. If homeowners think they can just call anything art and avoid HOA rules, it could open the floodgates. The appeal meant more legal fees, more stress, and more time dealing with this nonsense. But there was no backing down now. Victoria filed our response and we waited for a court date. In the meantime, something unexpected started happening. Other homeowners in Ridgemont Heights began pushing back against the HOA. Someone on the next street had been cited for having the wrong color mailbox. He filed a challenge, citing my case as precedent. A woman 2 blocks over had been told to remove decorative shutters from her windows. She refused and pointed the HOA to Judge Reeves's ruling about arbitrary aesthetic enforcement. Bob Yamamoto called me one evening. "You've started a revolution," he said, laughing. "Half the neighborhood is in open rebellion. Sharon is losing her mind." That wasn't my intention. I know, but it's beautiful. The board has been too aggressive for years. Someone needed to stand up to them. The HOA held an emergency meeting to address what Sharon called a breakdown in covenant enforcement. I didn't attend, but Bob filled me in later. Apparently, Sharon had proposed stricter rules and higher fines, but several homeowners showed up to object. The meeting devolved into chaos, with people arguing about everything from fence heights to holiday decorations. Linda Sorensen resigned from the board, Bob told me. Said she didn't sign up for this level of conflict. Kevin Blackwell is thinking about quitting too. Sharon's trying to hold everything together, but she's basically alone now. What about you? I'm staying on for now. Someone needs to be a voice of reason. But honestly, Zachary, this HOA needs a complete reset. The covenants are outdated, and the enforcement has been way too heavy-handed. In June, 3 months after the original hearing, our appeal hearing took place in Boulder County District Court. This was a more formal setting, with a real courtroom and everything. The district judge was a man named Thomas Hendricks, and he had a reputation for being no-nonsense. Walsh presented the HOA's argument first. He claimed that Judge Reeves had overstepped by essentially rewriting the covenant to protect my installation. He argued that HOAs needed the ability to enforce aesthetic standards, and that accepting my containers as art would make it impossible to regulate anything. Victoria countered that the original ruling was sound, and that the HOA was simply unhappy with the outcome. She emphasized that HOA covenants couldn't be enforced arbitrarily, and that residents had a right to creative expression on their own property. Judge Hendricks listened to both sides, asked a few clarifying questions, and then said he'd issue a ruling within 2 weeks. Those 2 weeks felt like 2 years. I tried to focus on work, on my garden, on anything but the pending decision. If we lost the appeal, I'd probably have to take down the containers after all. Worse, it would embolden Sharon and the board to crack down even harder on everyone. The ruling came on a Tuesday morning via email. Victoria called me immediately. We won. He upheld Reeves's decision completely. I actually shouted in relief. What did he say? He agreed that the HOA covenant was unconstitutionally vague in its aesthetic standards, and that you had a reasonable expectation that your display was permissible. He also agreed that the board acted arbitrarily. And get this, he went even further than Reeves did. He ordered the HOA to revise their covenant language to provide clear, objective standards for aesthetic regulations. Until they do, they're limited in what they can enforce. So it's really over. It's really over. Your containers are staying put. The HOA tried one more thing. Sharon sent a letter to all residents saying that while the board respected the court's decision, they wanted to remind everyone that individual property rights must be balanced with community standards. She urged residents to use good judgment in their landscaping choices. The letter was ignored by most people. The following month, the HOA held elections for board positions. Sharon ran for re-election as president and lost badly. A coalition of younger homeowners, tired of the heavy-handed enforcement, took over most of the board seats. Bob Yamamoto was elected president. His first act was to form a committee to revise the covenant language, as ordered by the district court. They spent months working with a lawyer and getting input from residents. The new rules were specific and reasonable. No junk cars, no dead lawns, no safety hazards. But they explicitly protected creative landscaping and art installations, with clear definitions and an appeals process. My container display remained through that summer. Some of the containers I eventually replanted with summer flowers and vegetables. Others I left as they were, part of the evolving installation. I moved some pieces, added new elements, and let it change organically. In September, the local Arts Council reached out. They were organizing a citywide art event called Art in Unexpected Places, where artists created installations in non-traditional locations. They wanted to include my container display as one of the official sites. I almost said no. The attention had died down, and I liked the idea of just having my garden be my garden. But then I thought about what Victoria had said after the first hearing, about making it clear that the display was intentional art. This would certainly do that. Okay, I told the organizer. But I'm not changing anything. You take it as it is. That's perfect. We love the authenticity. They added my address to the art walk map, along with 24 other locations around Boulder. On the designated Saturday in October, over 100 people came through Ridgemont Heights to see the various installations. About 60 of them stopped at my house. I stood in my yard, feeling absurd, as strangers wandered around taking photos and discussing the juxtaposition of organic and industrial elements and the commentary on suburban conformity. A few people asked me questions about my process. One woman said the installation reminded her of growing up in rural Vermont, though I wasn't sure how. Some of my neighbors came out to watch. A few seemed amused. Others looked annoyed by the traffic. Sharon Martinez drove by slowly, staring but didn't stop. The weirdest moment came when a reporter from Colorado Public Radio showed up and asked to interview me for a segment about art and HOAs. We sat on my front porch while she asked questions about creative freedom and property rights and community standards. "Do you think your case will change how HOAs operate?" she asked. "I hope it makes them think twice before fining people over subjective aesthetic judgments. I never meant to start a fight. I just wanted to keep some containers arranged in my yard. But it became bigger than that." Yeah, I guess it did. The interview aired a few days later. My voice sounded strange on the radio, but the reporter had done a good job contextualizing the story. She interviewed Victoria, Bob Yamamoto, and even a law professor from the University of Colorado who specialized in property law. The professor said my case was part of a larger trend of homeowners pushing back against overreaching HOA regulations. By November, things finally settled down. The art walk ended, the media attention faded, and life in Ridgemont Heights returned to normal, or at least a new version of normal. The revised HOA covenants were approved by a vote of the residents. The new board was functioning well, taking a lighter touch on enforcement and focusing on actual community improvements rather than nitpicking individual properties. I was in my yard one cold afternoon in late November, adjusting the containers for winter again when a car pulled up. A young couple got out, looking at the display. "Is this the famous art installation?" the woman asked. "I guess so," I said. "We're thinking of buying a house in this neighborhood," the man explained. "Our realtor mentioned this place, said it represented a change in how the HOA operates, more flexible, more accepting of individual expression." That's true. New board, new rules. "It's beautiful," the woman said, walking closer. "The way you've arranged everything. It's like organized chaos." After they left, I stood there looking at what I'd created. It had been almost a year since Sharon first showed up at my door with her tablet and her threats. The containers had survived winter, spring, summer, and fall. They'd been called clutter and called art. They'd been the subject of legal battles and newspaper articles and radio interviews. But mostly, they were just mine. An expression of what I found interesting and beautiful, arranged in my yard the way I wanted. In December, I added some evergreen branches to some of the containers and strung white lights through the copper pipes. It looked festive without being traditional. A few neighbors stopped by to compliment it. One couple asked if I'd help them design something similar for their yard. I said sure, why not? Christmas Eve, I was out front adjusting one of the lights when Sharon's car drove past slowly. She stopped, rolled down her window. "It does look nice with the lights," she admitted grudgingly. "Thanks. I still think the board was wrong to remove me. The neighborhood needs standards. It has standards now, they're just clear and fair." She nodded slowly. "You really put me through hell, you know that. You started it." A smile flickered across her face, gone in an instant. "I suppose I did. Merry Christmas, Zachary. Merry Christmas, Sharon." She drove away, and I never spoke to her again. I heard through Bob that she and her husband moved to a different neighborhood the following spring, somewhere with stricter HOA rules and no tolerance for creative container arrangements. The installation stayed up through another winter. I continued to modify it, adding and removing elements as the mood struck me. Some months it looked more structured, almost architectural. Other months it felt more organic and wild. The protection afforded by Judge Reeves's ruling meant I could experiment freely without worrying about fines or threats. In March, on the anniversary of that first court hearing, Victoria called just to check in. "How's the art?" she asked. "Still there? Still evolving?" "You know, I've gotten 3 more calls from homeowners in other neighborhoods dealing with similar HOA disputes. Your case really did set a precedent." "Happy to help, I guess. You should be proud. You stood up for something you believed in and you won. Not everyone has the courage to fight." After we hung up, I thought about what she said. I hadn't felt particularly courageous going into this. I was just annoyed about an unfair fine. But somewhere along the way, it had become about more than containers or money. It became about the right to make creative choices, to express yourself even in the regulated confines of suburban life. My brother visited from Kansas City that spring. He walked around the container display, shaking his head and grinning. "Only you would accidentally become famous for stacking pots in your yard," he said. "I'm not famous. Dude, you were on NPR. That's famous. It's not like anyone recognizes me at the grocery store." "Maybe not, but your pots are more well known than most people's entire lives." He had a point. The installation had taken on a life of its own. People still occasionally drove by to see it, though not as frequently as during the art walk. The University of Colorado's art department brought a class through to discuss it as an example of found object sculpture. A graduate student asked if she could write her thesis about it. I said yes. Though I never read the final paper through all of this, the containers just sat there, doing what they'd always done, holding space, creating shadows, existing in deliberate arrangement. The fact that they'd been at the center of legal battles and media attention didn't change what they were. They remained objects I'd placed intentionally to create something I found worth looking at. By the summer, I had started thinking about what would come next. The installation couldn't stay forever, could it? At some point, I'd want to change my yard, do something different. The protective ruling meant I could keep it as long as I wanted, but it also meant I was free to alter or remove it on my own terms. I decided to let it evolve naturally. Some containers I replaced with new plants. Others I moved to different locations. A few I removed entirely, donating them to a community garden. The installation became more sparse, more refined, less about abundance and more about negative space. In August, Bob Yamamoto stopped by with his wife. They'd been on vacation and wanted to see how things had changed. "It's quieter now," his wife observed. "That's intentional," I said. "The original version was very dense, very winter. I wanted something lighter for summer." Bob nodded approvingly. "You know what I like about this? It's not static. Real art changes and grows. That's what makes it alive." That resonated with me. The installation was alive in a way that traditional yard decorations weren't. It responded to seasons, to my moods, to new ideas and impulses. The legal protection meant I had the freedom to let it be whatever it needed to be. By fall, the installation had transformed into something almost minimalist. 3 tall containers in a triangular arrangement, a piece of driftwood bridging 2 of them, a copper pipe creating a vertical line. Simple, clean, intentional. Some people probably missed the more complex original version, but this felt right for where I was now. The second anniversary of Sharon's visit arrived in February. I marked it by rearranging everything again, creating a new configuration that referenced the original but wasn't identical. More containers, more layers, but with better spacing and clearer sight lines. I'd learned a lot about composition in 2 years, mostly by trial and error. A local gallery asked if I'd create an indoor version for a show. This time I said yes. I spent a weekend gathering containers from thrift stores and garage sales, then arranged them in the gallery's window space. The show ran for a month and my piece was titled Protected Installation No. 1, Ridgemont Heights. Some people loved it. Others found it pretentious. I didn't care much either way. The point was never to please everyone. It was to create something that felt true to my vision, whatever that was. When the show ended, I brought the containers home and integrated them into the yard installation. New elements mixing with old, all of it part of the ongoing project that my property had become. In March, the HOA sent out a newsletter celebrating the 2-year anniversary of the revised covenants. They included a photo of my installation as an example of creative property use within community guidelines. I had gone from being the problem resident to being the poster child for the new, more flexible HOA. The irony wasn't lost on me. That spring, I finally felt like the story had completed its arc. The installation was protected, the HOA had reformed, and I'd learned more about art, law, and community than I ever expected. What started as a simple arrangement of winter containers had become a symbol, a test case, and eventually just another part of the neighborhood landscape. On a warm April evening, I was sitting on my front porch with a beer, looking at the containers in the fading light when a young family walked by. Their daughter, maybe 6 or 7, pointed at the display. "What is that?" she asked her parents. "It's art," her mother said. "Why is it in the yard?" "Because the person who made it wanted it there." "Can anyone make art in their yard?" "Sure, as long as you own the yard." The girl considered this, then nodded seriously, as if filing away important information for the future. They continued their walk, and I smiled, thinking about what Bob had said. Real art changes and grows. It's alive. My container installation was alive. It had survived challenges, evolved through seasons, and created unexpected ripples through the community. It had been called Clutter and been called beautiful. It had been threatened and protected. Through it all, it remained what it always was. Objects arranged intentionally in space, creating meaning through placement and context. And now, 2 years after Sharon Martinez stood on my porch with her tablet and her threats, it was legally protected as art. Judge Reeves had made sure of that. My winter containers had become a permanent fixture, able to evolve and change but safe from arbitrary enforcement and subjective disapproval. I raised my beer to the containers in a silent toast, then went inside as the sun set behind the mountains, casting long shadows across my installation, my art, my protected expression of creativity in the regulated landscape of suburban America.